Partner in D.C. at Buckley Sandler. Hank's one of the most experienced trial lawyers in the country, having tried over 100 civil and criminal cases involving many high-profile clients. Most notably, or one of the most notable, is Governor Bob McDonnell, who he represented in his public corruption trial, and obtained ultimately a great result, including getting an appeal bond from the United States Supreme Court in 2015, which I think was the first time that had ever happened. And then about 2 years ago to this day, on September 8th, 2016, the government ultimately indicated to Hank that they were going to drop the case. And so, Hank's had his hand in a number of very important and high-profile cases, including shaping the way that public corruption and honest services fraud cases are going to be prosecuted going forward. So we're very pleased to welcome back Hank Asbill.
Thank you very much. Thanks very much, and we'll get started. With this panel. Let me introduce the distinguished panelists that we've assembled for this exercise. On my right is Ray Benoon, and the godfather of the white-collar programs, etc. Ray has obviously been a prosecutor for a long time in private practice for many years, and has now gone into private practice in his own firm, Ray Benoon Law, where he continues to represent corporations and financial institutions and audit committees and executives and anyone else who needs his help, and serves as an outside compliance counsel to multinational companies. And he's been a monitor for the Department of Justice in a variety of different cases. He conducts internal investigations and audits, formulates compliance programs, etc. And last but not least, he is a fellow of the American College of Trial Lawyers. Next to my far left is Randy Chardash, and he is a very able substitute for the person who's initially going to be on the panel, Paul Murphy from King & Spalding, whom I understand is still in ICE detention trying to get back into the country from a foreign vacation. But Randy is stepping in, and it's very fortuitous, because I think he's going to give us a very interesting perspective from the government side of things about joint defense agreements and practice. Randy has been practicing as an assistant U.S. attorney in Atlanta for more than 20 years, and is currently the senior litigation counsel for the healthcare practice there. And prior to that, for 12 years, he was the chief of the economics crime section in that office. He's a Miami Law School graduate and clerked for 2 federal district court judges in Miami before going into to practice himself. He's received many major awards from the Department of Justice, including the John Marshall Award and the Attorney General's Award for Exceptional Service. And, I just want to warn Randy to begin with that the topic here is joint defense agreements, not joint prosecution agreements. You get to have the joint investigation privilege, we get to have the joint defense privilege, basically. Both sides get to conspire, Randy. Next, we have Justin Offen to my immediate left, and Justin is a principal with PricewaterhouseCoopers in their forensic technology practice. He has the added distinction of not being a lawyer. He's a dual degree engineer, and he deals with a lot of very technical issues, technology issues, and can give us some advice, both in the context of assisting joint defense people or parties to a joint defense agreement in terms of how they manage documents and how they do forensic investigations and analyses, and to the extent that these joint defense groups ultimately end up in one way or another in a trial, I'm sure he can offer some advice and some assistance about how to best coordinate the documents and the other presentations during the course of trial, and to do those efficiently and effectively for everyone involved. And last alphabetically is Karen Popp to my immediate right. Karen is the co-leader of Sidley & Austin's white-collar and global compliance practice. She represents companies and individuals in high-profile matters all over the world, and has previously served in the government as associate White House counsel for President Clinton, attorney advisor to the DOJ's Office of Legal Counsel, and she was an assistant AUSA in the Eastern District of New York. Her most prominent present client is Urban Meyer, the coach of Ohio State, who has been very prominently featured and obviously improperly in a lot of ways in the press recently. This is going to have sort of two parts to the presentation. One is joint defense agreements in general and talk all about those. And in the context of investigations or inquiries that may or may not lead ultimately to prosecutions. And the second part of the presentation, hopefully, and would like to get a lot of audience participation. I know a lot of you have great trial experience in multi-defendant cases. And so we'd like to talk and open up the program at the end to the audience in terms of how do joint defense agreements that have been entered into pre-trial play out in trial. And so that will be the second part of this. But the first aspect basically is to try to figure out what these things are. Alternatively, they have been called joint defense agreements or common interest agreements. And I guess my first question to Ray is there any distinction with a difference between those terms?
Not really. I mean, I can only think of a situation where you may have want a common interest agreement versus a joint defense agreement if you really have foreign data privacy, data protection laws, and employment rights to consider, where joint defense isn't going to have a real meaning, but having a common interest may, although practically I don't see any.
So in terms of labeling the agreement, basically, assuming it is a written agreement among parties and their counsel, do you advise calling it a common interest agreement or a joint defense agreement, or is there case law that impacts that decision?
I mean, my problem is that I have a problem with both of these agreements because, as we'll see later, I just don't see, in light of DOJ policy, and especially the Yates Memo, how these agreements can really function effectively. Except for the benefit of maybe individuals, but in terms of making them truly effective where they can get company involvement, I really don't see that. So I think calling it joint defense is fine. I would prefer common interest only because joint defense has a connotation that you're jointly getting together to almost to maybe in the minds of some prosecutors to hide information or to figure out how you're going to avoid consequences of wrongful action.
Okay. Well, let's back up a little bit and just talk about, aside from the pitfalls going forward because of the Yates Memorandum, let's talk about what these things really do and what they establish. First of all, does anybody on the panel have any opinion about whether if you're going to have a common interest or a joint defense agreement with other parties to litigation or potential litigation? So, there's an inquiry or there's an investigation by the government and folks who are the subjects or targets of that get together. Do you want it to be oral or do you want it to be written? And what are the decision points for that analysis? Karen, you want to talk about that?
Sure. I mean, I think that having a written agreement certainly allows you to spell out and to make sure everyone understands the terms. And these joint defense agreements can get very complicated and very important as the case proceeds. There's obviously when it's in writing, however, there's evidence of it, and joint defense agreements are usually confidential. There's usually a provision in it that you can't even acknowledge that you're in one. But without there being something in writing, and I I've represented individuals and companies where I've been engaged in lots of JDAs. You don't sit on the telephone and orally walk through all the different aspects of a joint defense agreement that you may want to have ironed out if things go sideways in the case. And if you're ever litigating it and the court is looking at what the terms are. And so having it in writing, having provisions that define what is privileged, withdrawals from the agreement, what happens if one of the co-defendants becomes a cooperator, disqualification of you as counsel in the case, you want to have that provision as well. Having a lot of the bells and whistles that will protect your client, protect you as counsel, and also to be able to describe what is the scope of the agreement. Really, the only way to do that is in writing. But like I said, the downside is in fact that you've got evidence that there's an agreement. And frankly, you also have just cornered yourself into specific provisions that later, some people may want to say, well, that's not exactly how we agreed to it. But of course, that's what the written document will help prevent.
Well, does it make any difference to you how well you know the lawyers for the other defendants in the case in terms of whether it's in writing or oral? Absolutely.
I mean, I think that if it's one or more that you've worked with a lot, that you generally have an understanding of what are the terms of the JDA. There's a lot less concern that there's going to be a disagreement if there's ever a question about what are the terms of the agreement.
Although the problem there is you never know when a defendant may decide to cooperate and change
That's right.
lawyers. And then you want to be able to bind the new lawyer at least to what was discussed and obtained before the new lawyer came in. So once you have more than one or two individuals involved, I think written is clearly probably the better way to go.
Okay.
The other advantage to it in writing is that you usually want to have the lawyers, the clients, and any agents sign on to it. And so all the parties to the agreement have an understanding of really what it is when it's in writing.
By agents, you mean experts, for example, that the defense might retain, or
Correct.
investigators, or folks of that nature
Correct.
that have access to joint
Right.
defense materials?
Yep.
Okay.
Yeah,
Go
sorry.
ahead.
Yeah,
Go ahead,
on
please.
that point, as someone who would be operating one of those agent-type roles from the consultant or e-discovery provider, et cetera, not from the legal strategy, full disclosure, the written really helps resolve a lot of potential, he said, she said things down the stream, especially as Karen said, when things start changing or the roles start changing, have found ourselves in several situations where things that were agreed upon verbally, people remember differently when it was time to kind of start splitting up the data or information or how to change the coding panels, et cetera. Not to bore you with the details, but the written really makes everyone, I'd say, the universe of people involved much easier.
Well, in the experience of the people on the panel, whether you have a written agreement or an oral agreement, how frequently is it that issues relating to joint defense agreements are actually litigated, ever?
Not that often. I mean, in the cases that I've seen it happen, it's really when there's been one of the co-defendants have cooperated, and the question relates to the scope of cross-examination of that person, and some of the recent cases we've had. In fact, one recent one just had 11th Circuit that we discussed at breakfast. Randy may want to talk about it, but that found that once a co-defendant is cooperating, their expectation of confidentiality has expired, and so those are, in my view, the number of JDAs out there. It's quite rare to see something litigated in court over JDA.
Okay.
I have a question. So I will ask whether there's a joint defense agreement, and typically you get the Heisman from defense counsel. They don't do it, and there's some legitimate reasons, rather than, I know defense counsel think that it's some prurient interest of the government to ask that, but that may be partially true. But but it's more about, one is if there is a joint defense agreement, the government and government investigators can know to steer away from trying to, or if they get to situations where they may be a disclosure of some confidences of another person's, or in the in the joint defense agreement, so we can steer away from that. There's also an ethical obligation on parts of the government, as well as from defense counsel, to make sure that we have conflict-free representations. So to make sure that we're fulfilling our obligations, it's a legitimate, I believe, it's a legitimate inquiry of the government to ask, at least.
Right, and my response to you, Randy, is next question, please. But do you agree with me that, I mean, I assume that prosecutors assume that in multi-defendant cases, there are joint defense agreements, oral or written, period. I assume they think that that's generally the practice.
I think that we would generally view that there's a joint defense agreement, but we'd want to inquire about. Sometimes it's not. There's a changing landscape that was already described with the Yates Memo, and whether you can, in fact, thread the needle for a corporation to have a joint defense agreement and also want to cooperate, at least consistent with the memo itself. So there are things out there, it's changes, so that I think we just assume those because we just assume that the corporation's paying for everybody's defense fees and that they're all sort of, every day you're all going back and cooperating or deciding or discussing what's happening. We just assume sort of those things, sure.
Okay. And
So
obviously,
could
I'm
I
sorry,
ask
go
a
ahead. Yeah,
question?
please.
So, under the Larry Thompson memo, those of us who were around back then recall that JDAs were very taboo, and in fact, it could work against you, referred to as circling the wagons, and you might not get full cooperation credit if, as a company, had entered into a JDA with its employees. And so since then, we've had different iterations of that memo and moved forward, and JDAs were not supposed to no longer be held against you. So Randy, when you asked that question, are you in a JDA,
Yeah.
what's the purpose of it other than conflict? Are you going to use it against the company?
No, I'm not going to use it against the company. It's in my practice, and that you can enter into the JDA. There's nothing illegal, inappropriate, or wrong about it. We want to know what the landscape is. We want to know about conflict-free representations. We want to know how far we can go and make sure we don't invade some sort of broader attorney-client privilege. So I think we have some legitimate interest there, but there's nothing wrong with a JDA. I believe as we go progress, I think, because we've had this discussion earlier today about the Yates Memo kind of makes this a little easier for prosecutors in the sense of, if you want to cooperate, you represent the corporation, you want to cooperate, you're going to have to be very careful joining a JDA, because there are some things that there's a tension between the JDA and some of the terms of the JDA and what's contemplated in the Yates Memo regarding what full cooperation is. And again, if you can thread that needle, if you can navigate that, fine, great.
Okay, let me, before we go too much further in this, let me go to the next slide so we could just have some core understanding of some of the principles here. Yeah, here's the basis of it. In essence, you're extending the attorney-client privilege to someone in addition to your client. And that's the core idea. So anything, there is no obligation for any party to a joint defense agreement to disclose anything at all, to anyone else in the joint defense group, basically. But if you do choose to disclose information that otherwise would be confidential, you extend the protection, the attorney-client, work product, et cetera, protections to the people to whom you disclose. Correspondingly, if you do disclose if I disclose information to another person in the joint defense agreement, my client thinks X, or my client knows X about something, and I tell that to somebody, to the group as a whole, or to other individuals within the group, they are barred from disclosing that information further without my express and my client's express consent, either in writing or orally, depending on the terms of the agreement. So the party who discloses the information controls further dissemination of that information. That's the core of it. The purpose of all this, obviously, is to get access to other information that you wouldn't have a right to begin with, that might help you defend the case. And so you put in these protections to enable you to get that otherwise confidential information. And Obviously, to the extent that, that these people in the group coordinate, you can not only help coordinate defenses and try to, you know, avoid pitfalls, et cetera, in any kind of common defenses that might be raised, but you can share costs, create other efficiencies, essentially, in terms of divvying up research, divvying up interviewing of witnesses, et cetera, things of that nature, and sharing them with the group. But in my experience, the core provision in these kind of agreements, and we'll go through a sample in a minute, but some of the core provisions that cause the most concern to people negotiating a joint defense agreement are whether or not you can use misrepresentations or lies that somebody tells the group in cross-examining that person if they get out of the agreement because they're not cooperating with the government. So for example, and people fight about this all the time in the context of negotiating these agreements. If my client says to the group, the light was red, then cooperates with the government, gets out of the agreement, gives everyone notice, and now tells the government the light was green, and that's going to be the position at trial. Can that person be cross-examined with the fact that he's previously told folks in the joint defense group that the light was red? So what do you have any, and this is a big fight. Some people say, no, we're not going to agree to a joint defense agreement unless nothing that is provided by my client in the agreement can ever be used against the client if he leaves the group. Others say, no, we ought to be able to utilize, or we ought to be able to take advantage of lies or misrepresentations that someone makes. They shouldn't be allowed to mislead the folks in the joint defense agreement. Karen, do you have any sense of how to resolve that issue and which side you'd fall on?
You know, up until these recent cases, like the 11th Circuit case that we were just talking about a few minutes ago, I would have said that, you know, that's an issue you can negotiate, as you've just laid out. Obviously, me personally would want to be able to cross-examine anyone who leaves the joint defense agreement on issues that they are saying something different on the witness stand than they said within the JDA. But my reading of this recent 11th Circuit case would indicate that regardless of what the terms of the agreement are, that when someone leaves the JDA, becomes a cooperating witness, they lose their expectation of confidentiality, and they can be cross-examined.
I mean, I think that's a fundamental issue within and problem that arises with joint defense agreements, and that is that whether the information is being shared among attorneys or whether the information is being shared among attorneys and their clients or among clients or all those variations. And whether you have a provision in there that protects for this particular situation, that what happens if an individual leaves the joint defense agreement, and more importantly, what happens if an individual ends up being a witness, skip the co-op, but ends up being a witness, and states something other than what was discussed or what has been represented in the joint defense agreement. Is that covered by the joint defense agreement? And I think that becomes very difficult, obviously, to negotiate, because I would think every lawyer is going to want to protect for that potential possibility that they may get immunity and may end up being a witness. But that is really the most fundamental problem that one confronts in getting into a joint defense agreement, and in being willing to share information, knowing whether that information is being shared among the lawyers, because if it's shared among the lawyers, then you don't have to worry about the individual knowing what necessarily all the nuances of what was discussed. Yes, they will know generally what are the issues, et cetera, but not necessarily get to the point where, you know, they're saying to you the light is green and it turns out to be red or vice versa. It's the lawyer saying our position is that it was. So, and I think that's where how the joint defense agreement is entered into, and what Karen said, do you know the people you're dealing with? And how you're going to work together on that case? And to what extent, and whether you're going to be allowed to talk to the individuals that they represent. I think all of those have to be very clearly spelled out, because otherwise you're going to run into problems, even if it is not, even if you don't end up in court, you're going to have issues where there's going to be lawyers within the group are going to be careful what they disclose to each other.
So,
Let's break this down a little bit. I mean, obviously, this may or may not cross-examine somebody with information that they've provided to the joint defense group. One way of dealing with it, obviously, is to put a clause in the joint defense agreement that says if a party testifies in any future trial or proceeding, regardless, on his own behalf or for the government, or somebody who's compelled to testify, gets immunity, is compelled to testify, that party may be and consents, may be and hereby consents to being cross-examined by the attorneys for any other party to the agreement through the use of information obtained or derived independently from joint defense materials. And a party may use information contained in or derived from joint defense materials obtained from any other party pursuant to the agreement to cross-examine the person. So that is one way of trying to deal with this problem in advance. But there's another issue here. If you debate the concept of if you lie to the joint defense and then you switch sides, can you be cross-examined with that different representation, essentially? That debate, in my experience, tends to flesh out who are likely to be cooperating witnesses at the end of the day.
But does that raise, I mean, interesting, does that raise an issue from a prosecution standpoint, where you really are handcuffing, essentially, a member of the joint defense team from ever cooperating, because you're saying, you cooperate and we're going to come after you with everything you've told us. And it's essentially discourages cooperation.
I think that discourages cooperation, but certainly, the pure issue of whether or not you can get away with misrepresentations, or you flip-flop between when you're working for the government, when you're working as a defendant. If you flip-flop on the exact same issue, is that fair game or not? But I mean, the easy way around it for a lot of people is to say, no, anything I'm providing, you can't use ever, period, in. And that's.
it seems a couple things. One is the Almeida case was mentioned. It's actually been here around for a while in the 11th Circuit, where the 11th Circuit addresses this issue and says, we hold that when each party to a joint defense agreement is represented by his own attorney, and when communications by one co-defendant are made to the attorneys of the other co-defendant, such communications do not get the benefit of the attorney-client privilege in the event that the co-defendant decides to testify on behalf of the government in exchange for a reduced sentence. So the 11th Circuit has addressed this issue. Now, there are some distinctions you can make in this case, but they've addressed this issue and said it's fair game. What you've told in your joint defense meetings, and if you told either a misrepresentation or if you told a secret that perhaps the government couldn't find out or doesn't know about, you can get cross-examined by that. So now in this one is interesting. In this case, the Almeida case, it was an oral joint defense agreement. So perhaps there are some distinctions, although it's pretty broadly worded, about if you have specific provisions in a tightly written joint defense agreement. So perhaps there is a distinction there to be made. But generally, 11th Circuit, you're out of luck. But I had a question about whether the practice point here is that you don't bring your clients to the joint defense. I think Ray was speaking of this, to the joint defense meetings. You don't have them being examined. Is that what happens in these meetings?
I mean, I have never allowed my client in a joint defense agreement to be examined or appear at a joint defense meeting or be questioned by another lawyer. It's always been, you want to know something, ask me and I'll get you the answer.
Yeah, I mean, I think that's That's certainly the general practice that I've engaged in, although I have had some meetings where the clients were involved. But I think generally speaking, even though the agreement is amongst everyone, the conversations are usually between counsel. I will say the other thing that happens when you have one of your joint defendants to be cooperating with the government is that rather the JDA limits what can be said in the courtroom is one thing, but that defendant who's now cooperating, certainly behind closed doors can be telling the government everything that's happened within the JDA. And Randy, I don't know whether this is, you're familiar with this has ever happened on any of your cases where prosecutors have gotten into the details of communications that are otherwise should be privileged.
I mean, I can't tell you what happens in every case, but we, at least in my practice, to avoid that, I don't want to be litigating. It's always been sort of the view is, anyway, Randy Chartash, law license is not a good look. So I don't want to be litigating that with anyone. I don't want to get, we're here to play fair, and if I play fair, we're going to prevail. Our justice is going to be done, whichever way that works, and that's fine with me. And I'm willing to do that, and I think that's always been the ethic of certainly the Northern District of Georgia regarding it. So I don't want to get close. I'm not interested in asking. Oh, it's titillating. It's interesting. Oh, what were they thinking? What were they plotting? Everyone's interested in that. There's something about that. But, professionals, is professionally run office that we're not interested. We don't want to, we try to avoid those sorts of things because I don't want that litigation. I want to get straight to, keep your eye on the ball, which is getting straight to the prosecution, the indictment and prosecution.
If you've got a good case, why mess it up with these collateral forays?
Exactly.
Well, here's a provision that I've seen in a recent joint defense agreement that basically says client interviews is the caption. Each party in the party's sole discretion may provide other parties with access to his client for an interview for any purposes pursuant to the agreement. And that doesn't waive anything if you do that. But in my experience, very few people will make their client available to lawyers in the joint defense agreement for personal interviews, whether or not the lawyer is present. Much more often, the lawyers will talk amongst themselves about, well, my client thinks this.
Because,
my client
see,
might
that
say
eliminates the 11th Circuit problem.
Yeah. No, I agree. And the other interesting issue about, well, a lot of interesting issues, but do the clients always, do you always ask the clients to sign these agreements in addition to having the lawyers for the clients sign the agreements?
Yes, because you want to protect also, you want the client to understand what the significance of, obviously the client has to agree to be in a joint, to let his lawyer be in a joint defense agreement. So you would want him to at least sign, him or her to sign the agreement. And also it takes care of what happens if he changes lawyers or if he or she decides to cooperate independently. So I think it's really important to have that.
That's certainly my practice too.
Okay, well, and so I want to follow up on that. How do you these agreements can be multi-page. They're very complex, sometimes difficult to understand even for the lawyers who are writing and drafting and massaging the language. How do you deal with that in the context, for example, of a cartel investigation where you're representing in an antitrust matter Japanese clients or foreign clients? If it's difficult enough for us to understand these agreements, but how do you ensure that the client who only speaks a foreign language signs off on this knowingly, willingly, et cetera?
I think if you start having foreign clients and some of the activities occurred in another country as well, I think joint defense agreements become problematic because I don't know that you can rely on the attorney-client privilege of some of these provisions being recognized if the interviews occur through the assistance of a foreign law enforcement or agency. Because they may not recognize the attorney-client privilege in some of the civil law countries under those circumstances. So I'd be again, that would be something to seriously consider, and whether you, and how you deal with that situation, you may decide not to, at that point, have a joint defense agreement in that particular case, or have a more limited one.
So,
Go ahead, Karen.
just to add on to that, I think that, you know, from a U.S. law perspective, the JDA could still protect in a criminal setting, still protect the communications. But to your question as to whether the client understands what they're signing, my practice would still be to sit down and explain it to the client, not unlike explaining my engagement letter to the client. And just making sure that I do my best for the client to understand, because at the end of the day, as Ray just said, the client has to approve me enter into the JDA and having those communications about privileged information that the client owns, giving me permission to have those conversations with a co-defendant. So I would much prefer, in my endeavor to make sure the client understands that I also have them sign it. Because when someone signs something, they're more likely to spend time understanding what they're signing. And so it not only protects him or her, but it also protects me as counsel.
Okay. And Randy, I'll address this to you, and you may or may not have an answer. Is there a distinction at the DOJ in terms of how joint defense agreements are viewed between the criminal division and the antitrust division? And I see joint defense agreements all the time in antitrust cases, including the company. And I don't see that in any other area of practice.
Typically, they're bigger cases where where there are companies involved, so I think you might see them more regularly there. How they view them, I probably don't have particular instances, but I just would hope that they would view them similarly to us. But the joint defense agreements have been used for a long time in criminal practice, and the government has common interest agreements with relators all the time, so this is not a foreign concept to us. So, but I think there's some events that have happened. We talked about the Yates Memo and other things that make them trickier for defense counsel. I'm sure they're struggling or dealing with that issue, the antitrust division, but I don't know exactly if they have a specific view towards it different than what I've expressed.
Okay. Well, let's assume you're in a joint defense agreement. That's a written joint defense agreement, and people are banding together for common defense purposes, including cost savings and efficiency, et cetera. And Justin, how are you going to help us?
So, you touched upon a little bit earlier on that with the overview in terms of one of the main benefits is the reduction of costs. I think it's no secret to anyone in the room that humanity is creating massive amounts of data these days. I think the stats usually thrown out that we basically double our data population every year now in terms of what was existed in prior humanity. And that trend's not changing. The exponential growth is massive. And when you start thinking into not just the volume of data, but the complexity in terms of where it's stored, which ultimately translates to the complexity of having to acquire, forensically image, preserve, et cetera. I think in the last panel they talked about how the direction's going to cloud. Some of the estimates we see right now is 1/3 of all data will be in the cloud by 2020. Just to be clear, and again, I was touched upon a little bit earlier, the cloud does not sit in one magic little box. Google, for every search you type into Google, they use 1,000 different computers simultaneously. That's how the returns come back so quickly when they search the entire internet. So what that translates to is when it's time to start going into the preservation for discovery purposes, et cetera, the cost, as I'm sure all of you are familiar with working with electronic discovery providers, gets very high very quick. So when we're thinking about the joint defense, one of the main benefits of it is going through that exercise once, to the extent that there is commingled data, multiple data sources, et cetera. And then how can we pull that together into a single repository that the various members of the joint defense, various councils, et cetera, can all access in the most efficient means possible. And with the modern, e-discovery review platforms, Relativity, Recommind, some of the big ones, they can be configured in a way in which you can really securely, and obviously nothing's 1,000% secure, but for the most part, handle the flow of information, the communications, the discussion points, the tagging, the coding, all the things that are critical to the part of the discovery process, so that only certain people can view certain things, and not just the underlying documents, but the same review, coding, et cetera. So from a reduction of costs, it's basically, to oversimplify, it's provide a single repository of information that everybody can work off of. And not only does that help from the cost perspective and the efficiency perspective, but while you are fully teaming together, and again, you can work on the coding, so if there is any issues down the road, splitting off and bifurcating the data, it allows the teams to benefit from each other's insights and analysis to the extent that is beneficial and agreed upon as part of the defense. What we're seeing now more and more is you want to get away from the boil the ocean approach. It's, again, a very costly way to handle discovery as part of litigations or preparing for the litigation. So it's more the targeted analytical capability that it allows the more insight. And again, reference on the earlier panel, the technology-assisted review, right? Part of that is the machine learning piece. That is the computers, taking the inputs and the decisioning from the different reviewers to make the additional / incremental searches operate more efficiently, more accurately, et cetera. So having the more teams in there looking at that, if that information can be, again, leveraged across teams, it's going to allow the whole review process to expedite massively.
So your recommendation to the Joint Defense Group would be that the group itself hire one person like you, for example, to do for the group all of this work with respect to the technology?
Absolutely. And not just from, again, the cost of litigation, you're also getting into the business interruption perspective, right? When we're collecting information and data from corporations, from individuals, et cetera, for the most part, they're usually still doing their 9-to-5 job. And you want to minimize as much as possible either from an attorney fatigue, from a consulting fatigue, et cetera, you want the employees to be happy about as much as possible the process that's going on. So again, it's not just a cost perspective, it's a time efficiencies, and it's an overall business continuation perspective as well.
And I take it you personally or others that assist you in your company have experience doing this work in foreign countries as well?
Absolutely. Under white-collar crime, and I think you heard a little earlier, and I'm sure we'll hear more, one of the big things we look at is FCPA, or the Bribery Act in the UK, et cetera. So inherently, there's going to be a lot of complexities as soon as you start going into other countries or jurisdictions that have different privacy rules. GDPR, obviously one of the massive ones right now. And, it's interesting, some of the comments Ray made earlier about the various, working with international employees, et cetera. It's a very different process in terms of acquiring that data and information and synthesizing it and being able to prep it for the ability to review. And oftentimes, in that case, not in a single platform. I know that goes against a little what I said earlier, but still being able to have as much the similar structure and framework, because you might need to maintain a mirrored instance in somewhere in the EU for GDPR, or if you're in Asia, Chinese state secrets, Vietnamese state secrets, et cetera. South Africa's got POPI spinning up soon. Canada has recent new privacy laws as well. So the GDPR trend is going to kind of flow down into other territories, and while that's the main prominent one, more and more jurisdictions are applying similar type rules. So it really, it adds to the complexity of getting that data, analyzing that data, preparing that data for hosting. So again, having as much as possible a single instance as the jurisdictions defined, by the way. Again, obviously, if you need to have one within GDPR jurisdiction, et cetera, but having the minimal amount of touch points around that information, it's going to increase the efficiencies and, quite candidly, the accuracies. I don't think it's a super big myth, but even though it's the same software program, if you look at how you process cell phones, right? A big thing these days is mobile messaging. Whether it's the SMS or WhatsApp or WeChat, depending upon what part of the world you're looking at, the same exact application, the most industry recognized applications, Celebrite, Blacklight, et cetera, depending upon how things are processed, you can have some differences in the results in terms of the searching and et cetera. So minimizing the amount of incremental processing that's done is also going to help overall the corpus of information, not having running duplicative issues or slightly different version control issues.
Okay. Let's assume that there's a joint defense agreement in place, and let's talk about whether or not this is a sample agreement that's in your materials, basically, that I won't bother to go through the terms of. Any more of the terms of, but let's talk about the Yates Memorandum and the impact of the Yates Memorandum on joint defense practice.
I mean, I don't want to, I think the Yates Memorandum may have exacerbated or hardened the issue. The reality is that I think even preceding the Yates Memorandum, I cannot recall of a single corporation that I've represented that wanted to keep the option of making a voluntary disclosure or cooperating would enter into a joint defense agreement. And I think the reason for that, obviously, is that you want to keep your options open as to whether you're going to cooperate or voluntarily disclose or not. And if you are, you want to be able to not be tied with any other individual in any kind of formal agreement that's going to bind you from making full disclosure of everything. And now, under the Yates Memorandum, obviously this makes it much clearer that if you want to get cooperation and you have to cooperate against individuals, because that's a requirement, then having a joint defense agreement per se may be viewed as being unable to do that. So, but I think the trend has preceded, the trend of a company not entering into a joint defense agreement has preceded the Yates Memorandum. It's just that the Yates Memorandum made it much clearer that there's no advantage to a company to do that. Now, that doesn't mean you can't make some things available to individuals, such as their own documents, et cetera. But the advantage, there are really no advantages. A company has a right to interview its employees, will insist upon interviewing its employees, will demand information from its employees, and whether you whether you want to be involved in a system where that information is going to be shared among various employees, it's really not your advantage. In fact, what you want to ensure is that every individual keeps the information to themselves, that even your questions that you're asking.
All right, well, say, you're the general counsel of a corporation, a publicly traded corporation, and you come to me, and I'm in mid-management, and I'm in the flight path of something that's being investigated by the government, and you say you want to talk to me, or you want to have your outside counsel talk to me. And I say, great, that's fine. I'm happy to tell you everything I know. But I don't want you giving it to the government. So I want you to agree that, we have a joint defense agreement. I want you to have the information for your business purposes. But there's no way I'm waiving my Fifth Amendment right and giving you this information, which I know you're going to give to the government to be used against me.
If they want to remain employed at the company, they have to agree to be interviewed with no strings attached.
All right, well, do you give me my documents and a lawyer in advance before you jump on me and talk to me?
I cannot think of any instance when a general counsel or a company has agreed to do that, to give the documents in advance. Now, that doesn't mean you're not going to be able to show the documents, obviously, when you're asking to refresh recollection, but presumably you want to ask initially what the independent recollection of the employee is before you show them the documents, because you also want to test whether they're telling you the truth or not. So I think even more serious than that is whether you even allow a lawyer to be present in the interview, and if you do allow the lawyer to be present in the interview, what are the leeways that you give to the lawyer about interrupting or anything of the sort, or conferring with the client? I think companies, the larger the company, the more you have that issue where there's great reluctance to give an employee the right to have access to documents or put conditions upon being interviewed. And certainly, if you take the Yates Memo into consideration, I can't see how you can allow that.
Well,
So-
do you at least get the person a lawyer in advance of your interview, so the employee basically can talk to the lawyer about, what that person thinks is really going on here and what the issues are, et cetera, before the employee's interview?
I have, in some instances where an individual has asked to have a lawyer beforehand, I can think of a couple of instances where the company decided to tell the individual, you be interviewed first, and then we'll consider whether you ought, we'll provide you a lawyer or not.
You don't
So-
think the simple question answers itself? Do I need a lawyer?
Well, we will never respond to the question of whether you need a lawyer or not. That's your determination. That is not, we're not your, obviously you give the introductory,
Corporate brand warnings.
Yeah, I mean, it's telling them that you don't represent them, that you represent only the company, and you're not there as their attorney. So if they ask you the question, do I need a lawyer? The answer is, that is not something we can advise you, because we told you we do not represent you. That is your determination to make.
So on that point, and let me also address a few other points, but on that point, there are some bars, some states in this country that would require that if someone asks you, do I need a counsel, that you need to make sure that you're compliant with that bar rule. And I've had this happen in several of my cases, and the bar rules that apply are not only the bar that you belong to, but the place where you are doing the interview, and possibly the place where the headquarters are. So if you do get asked that question by someone, do I need a counsel, you want to make sure you check those bar rules before you answer it. In terms of the request for a lawyer, can I have my lawyer with me? One of the main concerns there is when you're interviewing an employee, that is protected by the company's attorney-client privilege. But if you interject a third party, which is counsel to the employee, you run the risk, probably not in the criminal setting because DOJ probably won't come after it, but perhaps if it's a publicly traded company and shareholder litigation, you do run the risk that the presence of that counsel could in fact cause the waiver of the attorney-client privilege. The last time I looked at that legal issue, it's really unsettled. There's a theory that the lawyer is the agent and stands in the shoes of the client, so it wouldn't be a third party. But other courts have looked at it differently, that is truly, a third party. There are countries out there, and I did the Stat Oil case, the FCPA Stat Oil case many years ago, and in Norway, all of those employees, and I was retained by the board of directors to do the independent investigation. Everyone got their counsel first. They were able to get documents first. So it depends on what country you're in as to whether or not a request for counsel, a request for documents could carry the day. I agree with Ray that in this country, it is, it's more the practice when you're representing companies that you not give materials in advance for the same reason the government won't give you materials in advance when you go in for an interview. And also the concern about having counsel present for the reason I just said, and also for the reason Ray said, that it could disrupt the flow of the interview. The joint defense agreement, what I've seen with Yates is Yates has been somewhat of a game changer in the sense that up until the Thompson Memo, JDAs were pretty common in my practice between companies and employees. And then Thompson comes and makes it taboo. And then after that, when Thompson got amended and the JDA language got eliminated, there was still the concern that if you tie the company's hands with any JDAs, that you're not going to be able to fully cooperate, which was the objective of the Holder Memo, the Thompson Memo, the McNulty, and now the Phillip factors. And so if you did enter into a joint defense agreement, you always carved out being able to share information that was obtained via the interview. When Yates happens, from my perspective, that really changes the dynamic of the way you represent companies, the way you do internal investigations for companies. From the perspective of, at the end of the day, the government, according to Yates, is going to want to get all of the information in order for you to get cooperation credit. They also have now more of an incentive to go after individuals, which means you have to, and I know there's been prior sessions on Yates and what it really means, but certainly In my practice, I've seen a change in the way you do the investigations. You actually now not only look at going after issues from a collective liability, corporate liability perspective, but also from an individual perspective, because at the end of the day, DOJ is going to want to not only get a briefing on your findings from a corporate liability perspective, but also on the individuals. If you have JDs in place in order to get all that information, you've just tied your hands to get that type of cooperation credit that Yates lays out that you need to give in order to get it. So while I agree that it's not like it used to be, it is certainly somewhat different when it comes to JDAs.
Well, how do you, I mean, in terms of advising the corporation, you know, there are business issues here as well. And how do you deal with the fact that in a large company, people get involved in complex transactions and they're in the flight path and somehow it becomes an SEC investigation or a DOJ investigation or whatever. And simply by virtue of being in that kind of business milieu, these people are, you know, in the flight path of this, basically. And if you do not treat those people fairly, if you do not provide counsel for them, if you do not assist them in some way when they claim they are innocent, they did nothing wrong, you know, how does that affect your ability to hire people? To retain
First of all,
people?
it goes back to your compliance program. And I think in the companies I'm thinking about, the compliance program is very clear in training. They're told, you may be in a milieu or an environment, as you put it, where some of these things happen. We don't do it at this company. So if you do it, there are going to be consequences. And we're going to investigate it, and we're going to talk to you, and we're going to get the information, and we may very well end up cooperating with the government. And I think they actually literally say that in fact, in one company that is not even publicly traded that I represent, but it's a significant multinational, privately held company, but it's so big that it might as well be, and it's regulated. They basically, there's a message from the principal who says, you do something that messes me up, messes my name, and you are in trouble. And you're going to have to answer to that. So I think it goes back to when you talk about culture and how do you get the culture, I think it goes back first to your compliance. And then when there's an investigation, yes, you're right, it does create, it does change. The culture in companies has changed from what it was 20 years ago when a company used to protect its employees, used to pay for them, used to take care of them, used to enter into joint defense agreement. It has changed. And yes, there is sometimes worries on the part of employees, am I going to be protected and not? But I think that's unfortunately one of the consequences when you have a policy that says if you want to if you're going to cooperate and want to get credit for not being potentially prosecuted or getting a declination memo, you have to, we're not going to close the case until you've cooperated and given us the guilty parties, essentially, within your company. That's
the Yates Memo.
That's right. That's one of the consequences. And when you're talking about being in most of these companies in highly regulated industries, where you could get disbarred, where you can debarred from various government contracting, et cetera, that's a very significant financial consequence, not only to the shareholders, but also to all the other employees who are going to suffer if you do not do it, they do not protect the company.
Okay.
So your question raises the point that there's actually two time periods that we should consider when we're thinking about these JDA questions. One is when you're engaged in the internal investigation.
Right.
And you are needing to interview everyone, find documents, and before you start presenting to the government what your findings are. And in that setting, because of the Yates Memo, you have to be very careful to enter into JDAs because you're tying the company's hand to turn everything over that the company may want to turn over. So that's in the internal investigation stage. On the flip side, on the back side, after the investigation, after the government's investigating, the government is actually going now focusing as a result of Yates on individuals. The question, and then the government wants to start talking to people, bringing them in for interviews, which we now see a lot more of. The question is, at that point, should these individuals have counsel, and should the company pay for counsel? It's been my experience that certainly if it's individuals that are covered by D&O, individuals that are covered by the bylaws, officers, the company definitely will get counsel put into place. And then at that point, what does the company counsel do to educate those individual counsel about their clients? And that's again where I've seen a change as a result of Thompson and now Yates. You used to basically have joint defense agreements where the company counsel would basically present to you what they found in their internal investigation, tell you everything, give you access to documents, that relate to your client in any way. Today, that doesn't happen anymore in my experience. What happens is a much more skinny down overview. You're basically going to get documents that have a to and from with your client. You may get access to interview memos. You can read them. You can't take copies of them. And then if another government's involved, like I have a case right now where the SFO is involved, the SFO usually requires the company not to share anything with its employees. And I'm in a case right now where, thank goodness, the company has both DOJ and SFO, and DOJ wants to speak to my client. I represent a senior officer in the company. DOJ is going to be sharing the documents with me because the company cannot because of the SFO. So, you know, and this is all because they want to sit down with my client.
I agree with Karen. I mean, and that's what would happen, and I think it's very important to keep in mind that, especially if the SFO is involved, because a lot of cases nowadays could involve the United States and England. The SFO has a much tougher approach to they will tell you. I mean, the Justice Department's policy is not to tell you what you can and cannot share. However, you know what the expectation is ultimately because you can read the Yates Memo.
It sounds to me like I'm kind of tearing up here about, it looks like the Yates Memo has been a wild success.
Apparently for some it has. Yeah, Randy, let me follow up on this. I mean, you don't care, I take it, that corporations choose to pay, whether they're statutorily or contractually obligated to pay counsel fees for individuals. Do you care whether or not they voluntarily do that?
No, I don't care whether they do that. No, again, it's part of either the bylaws or it's part of the statute or something like that, where corporations will pay. We have this conference because corporations pay, legal fees and that sort of thing. So I don't care. It doesn't bother me. Some attorneys, some prosecutors do get wrinkled, get their nose out of joint a little bit about it, but there's nothing to do about it. Perfectly legitimate. So again, keep your eye on the prize, keep your eye on doing the investigation. So I don't care that.
Even if it's not required, if it's just voluntarily done by the corporation because that we're good guys and that's what we do for our employees.
Even if it's not required. I mean, I believe, as we talked about the last conference, at the last segment, when the question was, well, do you think the government's going to do the taint team right, or you think they're going to slip the really hot privileged document over? No, that does. I will tell you, do people make mistakes? Of course. Are there exceptions? Yes. But no, I think the general thing is we act in good faith, and no, we're not slipping it. And I've done dozens of taint teams, and that does not happen. And similarly, I believe that defense counsel, they have ethical duties and will abide by their ethical duties and protect their client's interests and have a duty of loyalty to their client. And that's the way the system works.
Okay. Well, we know that after the Yates Memorandum, the corporations or the companies, at least to the extent that they are publicly traded and in regulated areas, are not going to enter into joint defense agreements with the employees. If it's a private company, basically all bets are off. You can do whatever you want. Any comments on that, Ray?
Yeah, I mean, it depends on what kind of private company. If it's a private company that's really multinational in nature, where the ownership is really, it only applies really where the ownership is so tied to the company that there's really, you can't call it, there's no independence between the two, really, where you don't, where the board is really the owner, whereas if it's a private company with a large board that has independent members, et cetera, then you really, and that's also regulated, then obviously you're going to treat it more like a publicly traded company, except that it doesn't have to worry about some of the SEC books and records issues. But so I think that's very different. I mean, I've been involved in situations where it's a privately held company that's really all over the world, but the owners are in tight control of everything. They are the executives, they are the board. In that case, really, you say, hey, from the very beginning, we're not going to be cooperating. You know, there's not going to be cooperation there. And there, it's back to really you decide, you know, you can enter into joint defense, you can do a lot of things because you know that there's no way to separate the company from shareholders.
I think it, as Ray said, I think it really depends on the entity and what industry they're in, what type of entity. I do a lot of work in private equity, hedge fund, life science, which can have privately held companies, nonprofits. And, you know, companies, whether you're private or public, if you have a brand or you're in a heavily regulated industry, you're going to want to play by the same rules that a public company is. On the other hand, if it's a smaller company, even though you're playing by the same rules and everyone knows each other and the owner basically, you know, runs the company, it's more likely that you know, person is more than happy to pay for fees. So I think the devil's in the details in terms of my experience as to how that plays out. I do know also from representing public companies that there is always an endeavor when you find yourself in an investigation and you've got employees being interviewed, you really do endeavor to try to get people lawyered up before they go in and have to interact with the government and go through an interview.
Yeah, I think
that has been my experience.
Once you get to the stage of interviews by the government, there will definitely have representation, and the company will pay for it. Of course, the problem is by then, they've also been interviewed by the company, and if the company is cooperating,
You've turned over those
you know,
memos.
even if you haven't turned over the memos, you've
them.
really briefed them on what they've said.
Yep.
So, and frankly, I could think of one particular instance where the main culprit, the whole case against him, dependent upon the interview we conducted, because the government was not able to interview him because he took the fifth. So it literally became the case. He got convicted solely based upon the documents, but more importantly, how he reacted to those documents.
Okay.
Good morning. I have a two-part question. It kind of goes back to what Ray said when you said that you wouldn't bring your clients into the interviews. Is there any benefit to bringing them to the interview? And then just based on what you said just now, should that particular person in that situation, should he have just pled the fifth in his original interview with you all too?
Well, he wouldn't have been able to. He would not have been able to because he was a longtime employee of the company. He was not represented. He frankly was pretty arrogant and thought he was going to fool us, and didn't realize we had the documents already, because he didn't think he had actually wiped out all the computers, but he didn't know that there was a server that had the documents. And so, but it's, you know, you're right. I mean, if I represented that individual, I would have advised him not to go in and be interviewed. The problem with that is he would have lost his job. And so you've got this very difficult, it's very difficult for an employee who has a good job, who believes that he's respected, and this guy was respected, very highly respected. There was great doubt. The management couldn't believe that he might had any involvement in any of the conduct. And even seeing some of the documents, some of the correspondence, they still couldn't believe it and tried to find justification. So he really believed he was well positioned in the company and did not want to lose their job. So you're right, he's put in a very, very difficult position. I agree with Karen that you do have to consider in some instances whether if the person has asked for a lawyer, you can deny him a lawyer. We always tell the individual we interview that the company retains the right to disclose the information to anyone they want to disclose it to, including the government. So they know that whatever they say is only confidential in terms of what they can disclose, but not in terms of what the company can disclose. And so the fairness, from a fairness standpoint, is it fair? No, it's not. It's not fair. But but the reality is that's what right now companies are, the difficulty they're placed in, where they have to think about the greater good of the company and the shareholders.
So from your perspective of representing an individual, one of the first things you want to ask is, does the company who's insisting on an interview and an interview without counsel, does that company have a corporate policy, a compliance policy, that its employees must cooperate with internal investigations? Because if the company doesn't have that, you may have an argument that he or she can't lose their job. So companies today usually have that so that you can hold the job over their head to get them in to do the interview. But there's still some companies out there that don't have compliance programs and may not have that policy.
Especially if he or she is employed in a foreign entity or in the foreign subsidiary or foreign office, even foreign office of a U.S. entity, because under the labor laws there, the employment laws, they will have rights to see some documents, to even have representation possible.
And then the other thing is these bar rules that I mentioned a few minutes ago. There are some bars that not only require you follow a certain protocol if the employee asks you, do I need counsel? You also have a burden if you know that the person you're getting ready to interview, that they are culpable, that you suspect that they're culpable, that you may have an obligation to tell them in advance. And I had a case, and Minnesota is one of those states, where you have to give notice in advance of the interview that they may want to consider retaining counsel. And so under that situation, the company, under the bar rules, could not proceed with an interview without allowing counsel to be consulted. Doesn't necessarily mean the counsel can be in the room, but to be consulted.
Yeah, and I actually, to add to what Karen said, I can think of one instance where we actually had a very damaging, one or two very damaging email against a particular employee, where we did advise him to get counsel, and when he refused, we actually did get him someone to at least consult with before we interviewed him, and we did show the document that he created to the counsel, and ultimately, when he still insisted on being interviewed, we did allow the lawyer to sit in on the interview. We said, look, you're not going to be allowed to participate, but you can sit in. The reality is, we were going to be very flexible and see how it flowed. But we did that because it was very clear that the individual had significant exposure. Now, conceivably, I'm not saying he would have necessarily been prosecuted, because he probably could have implicated others and avoided it. But because of those very damaging documents, we did do that.
Now, and just bringing this topic back to a JDA, I had a situation where we did an internal investigation. We found all sorts of stuff. We followed it up to the most senior person, who then became the, sort of the big fish of the internal investigation. By the time we wanted to sit down with him, he had gotten a counsel, didn't want to talk with us. without the counsel being in the room. We really wanted to talk with him. We wanted to know what he had to say. We were in a cooperation mode with the government. And I was very concerned, because it was a public company, about the waiver issue. And so we entered into a limited JDA that allowed the counsel in the room for purposes of maintaining the privilege, but with a carve-out that that we could disclose to the government what happened in the interview room. He got what he wanted, which was to have counsel with him. And I then fronted the issue with DOJ to let them know that this was going on, and basically got it blessed. So we were able to do the interview without waiving privilege for purposes of shareholder litigation. He could have his counsel in the room. We got our interview, we got disclosure, we got a declination. He got indicted and went to jail.
The one thing you need to be very careful, and in particularly, really not only be very careful, but in particular advise the general counsel to be very careful, and even management, that if the employee asks, should I have a lawyer, or should I consult with a lawyer, you want to make sure, because you're clearly not going to advise them whether they should or shouldn't, but you want to make sure the general counsel and executives, if he goes to those executives, will not tell him something to the effect of, we'll let you, you don't need them now, but we'll let you know when you need it, or anything like it, because you really, it has to be very clearly, we cannot advise you on that issue. That's your decision.
Ray, let me interrupt for a second here, because we don't have a lot of time, but let's assume you got the joint defense agreement in play before people are indicted. And then they're indicted. And aside from complying with the terms of the joint defense agreement in the trial, whatever the terms of the agreement are, you can't violate those terms just because you are in trial together. But what are some of the thoughts about how people should try to cooperate if they're multi-defendants in a trial? Not that they're required or obligated to do it pursuant to the agreement, but what are the sort of best practices in terms of trying not to become additional prosecutors in the courtroom with your co-defendants? And so what sort of strategic insights do you want to share about that?
I mean, clearly, in all of in any multi-defendant case, you've got to streamline everything. You do exchange. I mean, if you're part of a trial team, and there's a common interest in the result, you know the attorneys are going to be cooperating together as to how they're going to proceed in the trial, so they don't look like they're opposing each other in the courtroom. That they're and also under the rules of the court that probably the judges imposed, you're going to have to. You can't keep asking the same question simply because, or cross-examining a witness on the same point. You may decide one person is better off doing the cross-examination than you, et cetera.
Do you, among the defense teams, say the three defendants, and among the defense teams, do you try to cooperate and suggest that you particular lawyer would be the best person to make this legal argument, or you would be the best person to argue the reasonable doubt concept for the group,
Yes.
et cetera? And do you try to strategize collectively about the limited number of strikes you get during the voir dire process?
Yep, you
even though
do.
you have different clients and different sort of shades of the defense. Even though there's a common defense, there are variations on that theme.
Yep,
essentially.
Yeah, you do all of that. And this question again has sort of two aspects. One from the JDA, and obviously you're confined to what you've agreed to within the JDA, how you can and can't use information even in trial. So that's one aspect. But the other is just the practical dynamics that you're now talking about.
Right.
Sort of how is it that the defendants want to function as joint defendants in a trial? And how can you as counsel defend your client without breaching sort of that understanding of how the defendants are going to not point the finger at each other?
Should the degree of cooperation decision be made by the client or by the lawyers for the client?
Jointly. Obviously, you have to advise the client what's in his best or her best interest, and why. But I think the client has to buy in.
At the end of the day, it's the client.
Right.
They're going to have to sacrifice in some ways if they're going to
gotta
pursue
be
a
the
joint
client's
defense
Right, because
strategy
they
during
have
the
to
trial.
understand why does it make sense for only one person, one lawyer to do the cross-examination of one particular witness, or et cetera. What's the advantage to them? And they have to buy into it, otherwise,
You're
you
buying
know.
yourself an ineffective assistance of
right.
counsel claim after a guilty verdict.
Okay. We don't have a lot of time left, but I want to open up to questions if anyone has any before we really run out of time. Yes, sir.
Just a question about in this JDA's situation where you have parallel investigations, could be in civil CIDs as well. And we do a privilege log, and you'll make a certain privilege over some of these documents that were gained pursuant to the JDA. The question I had is the written agreements themselves. When I researched that, I found some mixed case law as to whether the agreements themselves were privileged. What's been your experience about producing the agreements themselves, including from our DOJ brethren?
Well,
What's your experience about demanding production of the agreements themselves?
yeah, well, you certainly can have a provision in the agreement that it's confidential, that the terms are confidential. I think, there's a question as to whether the existence of the agreement is confidential by virtue of that provision. And I'm not sure if those are the cases that you're referring to, but certainly if the contract itself, because it's a contract, so it's a construction of contract issue, if the contract itself says these terms shall be maintained in confidentiality, then court should uphold that as opposed to the existence of the agreement.
I guess the confidentiality versus privilege in the law enforcement investigation, I'm not sure whether or not those, so my solution wasn't to, if there's information in it that had its own privilege, you can't make something privileged just by calling it privilege, didn't have some privileged nature of it. We redacted anything that would seem like it would reflect on processes or otherwise of the attorneys.
well, I don't know if it's privileged. I think it's more a contract, isn't it? A contract issue that you state in the agreement that it be, because don't forget that
parties.
a lot of the things that you may be exchanging are factual things that may not rise to the level of attorney-client privilege. Maybe work product, maybe, So I think the agreement itself, and I have concerns about an agreement that says that nobody can disclose its existence, but that's a contractual, whether it's going to be interpreted as a contract and a binding contract, and you can't, so you wouldn't put it in a privilege log.
So yeah, that's the question, is would you refuse to produce it to DOJ if they requested?
I,
Would you have to?
Well, that's why I've always actually had a concern with that, because if you're asked, do you have a joint defense agreement, and you answer, I can't comment, or it's pretty obvious you had one. So I think that provision in my view, is counterproductive. You're much better off saying, yeah, we did have a joint defense agreement, so what?
So most of these joint defense agreements, are the ones that I do, have a provision of what happens if one of the parties is being compelled to produce the document, giving notice to the others so that they can intervene and
Right.
try to prevent the production.
Okay, any other final questions? I know we're out of time. Yes, sir.
One quick thing. This is a very different district than here, but the thing that concerns me about maybe hopefully an unintended consequence of the Yates Memo is the rise of something that I would describe as a prepackaged prosecution. Where the company does an internal investigation, they decide who it is that they're going to sort of offer up as the people involved. But they leave out key people, and they deliver it in a way to the government that makes it all too easy, because the narrative, fits a case that could result in convictions at trial, and they provide certain documents, not others, they make certain interviews available, not others. And in the case I'm talking about, extraordinarily, the person who actually designed the mechanism and scheme can compel lower-level employees to create a white paper that was then used as the basis for an obstruction count, was never contacted by the FBI or by the U.S. Attorney's Office. They didn't get so much as a phone call. And the government happily went through with that prosecution. They did get, people weren't convicted on all
going to say is that, you know, the one thing that Yates says is, and I'm looking at it right here, all relevant facts. In my experience, I mean, I was in the middle of a major investigation where I was representing the board, and was in the middle of doing a series of meetings with the government presenting when Yates came out. So Yates comes out in the middle of these series of meetings that I've had with the government over a period of time. And we were just wrapping up when Yates came out. And at the end of it, I got a request from the prosecutors to come back in and now present the evidence, not from the perspective of the corporate collective liability doctrine, but from the perspective of all the individuals and what evidence we had on each of the individuals. So my experience has been that it's not, you can't just prepackage like that. Now, that it is, you're investigating, you're going into an investigation, internal investigation, without an end result. I mean, you are following the evidence. And then you present that evidence now to DOJ under Yates. You have to present it all. And then they also want to know what you found, not only from a corporate perspective, but from individuals.
I think.
But does it happen with others? I have no idea.
I mean, I think what you're saying is that you run the risk as a lawyer, and you know, if representing a lot of clients, that your credibility is going to be impacted eventually, because all the government has to do, all the prosecutor has to do is say, well, I'd like to interview some of the people, do their work, you know, which in many instances, I would say in majority of instances, prosecutors do their work. And certainly at Main Justice, they do ask to interview people.
That's a very common practice
And
post-Yates.
so I think the danger of having this prepackaged thing where the a company and outside counsel prepackage who they're gonna sell is really, can have really bad impact, consequences for your reputation as lawyer in terms of your future ability to represent clients and to have credibility.
Thank you, Ray. I want to thank all the panelists for getting the cut sign here. Thank all the panelists. And Randy, I hope you will ask to be the prosecutor in all my cases.